Hello, everyone, and welcome to Google v. Oracle, an initial appraisal. Please keep your microphone muted and your camera turned off throughout the program. Feel free to use the chat function to submit your questions to Questions Richard Fisk at any time. Note that this program is being recorded. The recording will be emailed to all registrants within the week. If you are attending for CLE credit, follow the instructions indicated on the GVO event page to sign in. This event page is linked in the chat box. Note that the sign-in will permanently close on Tuesday, May 4. I will now turn it over to the Executive Director of BCLT, Jim Dempsey.
2 weeks ago, the Supreme Court handed down its decision in Google v. Oracle. The facts and holding are easy enough to state. Oracle owns a copyright in a computer program called Java SE. Google copied certain elements of the Java SE code for use in the Android smartphone. By a margin of 6-2, the Supreme Court held that Google's copying was fair use and therefore did not violate the copyright law. In reaching this holding, the court assumed but did not rule on whether the copied elements were copyrightable in the first place. The case has been called one of the most important copyright cases of our time and one that is immensely important to innovation in the computer software sector. To discuss the case and its implications, we have a stellar lineup. We're joined by Professor Sean O'Connor. Sean is a professor of law and executive director of the Center for the Protection of Intellectual Property at the Antonin Scalia Law School at George Mason University. His research focuses on intellectual property and business law with regard to startups and commercializing technology and arts innovation. He's currently completing a book entitled The Means of Innovation: Creation, Control, and Methodology. Pam Samuelson is the Richard M. Sherman Distinguished Professor of Law and Information at the UC Berkeley Law School and at the UC Berkeley School of Information. Much of her work has focused on updating and adapting US copyright law to meet the challenges of the digital age. She has written numerous articles on this issue, which are linked to in the resources page accompanying this webinar. She filed an amicus brief in the Oracle v. Google case. Professor Samuelson is also chair of the board of directors of the Electronic Frontier Foundation and president and chair of the board of the Authors Alliance, a nonprofit organization that represents the interests of authors who want their works to be widely available for the public good. Peter Menell is Corrett Professor of Law at UC Berkeley Law School, co-author of the leading casebook on intellectual property, editor and co-author of the Patent Case Management Judicial Guide published by the Federal Judicial Center, author of numerous law review articles and amicus briefs. Professor Menell's first article on the issue of today's webinar, that is the copyright protection that should be accorded to computer code. Professor Menell's first article was actually written in 1986 for when he was a student in a seminar being taught by then Judge Stephen Breyer. And finally, we're very pleased and honored to have Tom Goldstein. Tom is one of the nation's most experienced Supreme Court practitioners. He has served as counsel to a party in roughly 125 merits cases before the Supreme Court and has argued 45 cases before the court. Only 3 lawyers in the court's modern history have argued more cases in private practice. And he's been counsel on more successful petitions for certiorari over the past decade than any other lawyer in private practice. The scope of Tom's representation of clients in front of the Supreme Court is just remarkable. As arguing counsel, he has prevailed in cases involving arbitration, bankruptcy, civil procedure twice, copyright, disability law, employment discrimination twice, the Fourth Amendment twice, free speech 3 times, habeas corpus 3 times, immigration, labor, maritime torts, securities, and trademarks. And he's not associated with any particular perspective or ideology. Again, the scope of his clients is remarkable. He's prevailed on behalf of bond purchasers, corporate civil defendants, corporate civil plaintiffs, a debtor, employees, a habeas petitioner 3 times, an immigrant, investors, an individual civil defendant, an individual criminal defendant, a local government, Navy veterans and their estates, persons with disabilities, and shareholders. Just remarkable. Tom, congratulations on winning Google v. Oracle, and thank you very much for joining us. Kicking it off with you, Tom, why do you think the court here went for fair use when so many of the briefs and the dissenters wanted the court to rule on whether the elements of code at issue were copyrightable at all? Why fair use and not go to that copyrightability question?
Well, the court is always concerned, and first of all, thank you so much for having me. The court is always concerned, of course, of getting to 5, and it really wants to have a single theory of the case that will be a legal holding that doesn't reflect a plurality or internal divisions and that sort of thing. And it was pretty apparent at oral argument that there were several members of the court that had real questions about our copyrightability theory and how it would work, its broader implications, the sweep of our position with respect to the merger doctrine and the like. On the other hand, there did seem to be a pretty broad sense that we were right in the end result. And so fair use, given its flexibility, really did provide kind of the easiest pathway forward. That said, I think a lot of people were concerned about fair use because it might come across as entirely fact-bound. We did have an argument that this jury verdict was entitled to deference, and the court actually disagreed with us about that and gave us the broader holding, which I think made the software community happier, that this was fair use as a matter of law, a ruling that will apply to a lot of cases. So I do think they wanted to settle this particular question, but were concerned about the scope of the copyrightability question, including for what it would mean for the copyright protection for computer software generally.
You were arguing before a 8-person court. The last time the Supreme Court considered the question of copyrightability, it split 4-4. In this case, of course, a 4-4 split would have been a defeat for your client. When Justice Ginsburg passed away just, I think, weeks before the oral argument, did you have a deja vu all over again moment and worry that you might get a 4-4 split again?
Well, of course, we all miss Justice Ginsburg terribly. I will say that Oracle probably missed her more terribly than most, because Justice Ginsburg was extremely familiar with copyright law and had a very pro-enforcement perspective that would have been, deeply respected by other members of the court. You never know, and we were certainly not counting any chickens before they hatched. I did feel that the cert grant was a very good sign for us, although the participation of the Solicitor General against us was a bad sign. There was always the very real prospect, however, that in Lotus versus Borland, Justice Stevens recused. And so there was nothing to do about the 4-4 tie. If we had had a 4-4 tie here, it's quite likely we would have had the case re-argued. And it would have gone into a 3rd term. This was one of the last cases that didn't get argued because of COVID a couple of terms ago. Then it got rolled into this one. And if it had had to be re-argued again, then this would have been the lawyer's gift that keeps on giving.
Yeah. Already a 10-year long case. And still not over with, which we might talk about at the very end in terms of what's next, at least for these 2 parties. Let me turn this question to Peter. Peter, Tom explained that the court, and Justice Breyer, as the writer of the majority opinion, was aiming for a clear majority. Fair use was the way to get there. But did the court really sidestep copyrightability, or did it seem that at least Justice Breyer, in his opinion, had an opinion about copyrightability?
Well, I think Justice Breyer is someone who has been thinking about these issues for a very, very long time. His article in 1969 was really one of the first to touch on copyright protection for software, and it was an issue that interested him greatly. I read the opinion as methodically addressing copyrightability through the lens of fair use. That when you go through section by section of the opinion, you see all of these references to the thinness of copyright, to methods of operation, to functionality, to interoperability being really about function, to the fact that the declarations were not creative in their expression, they were functional in the way in which they operated these method calls. In fact, towards the end of the opinion, he says, in our view, the declaring code is, if copyrightable at all, further than are most computer programs, such as the implementing code, from the core of copyright. And my view, has been that although it was somewhat odd for Congress to bring software into copyright, that the way in which it intended to do so was as a very thin protection, because that statute, the 1976 Act and the 1980 amendments, were very much about enforcing the limiting doctrines as well. And so the way we get there is by protecting the code as a sort of long document, but not protecting the way in which it operated a machine, a computer. And so I see the opinion as really addressing both issues. It's just going to take some time before that teases out in cases. And frankly, after Lotus versus Borland, there really was no major dispute over these questions for a dozen years. It wasn't until Oracle acquired Sun and brought this case that this became a hot button issue again.
And we'll maybe get to that arc and sort of where we are on the arc of understanding the application of copyright laws to software in a little bit. I do encourage people in the audience. We have a huge audience today. Those of you who are on Zoom, I welcome you to use the chat function to send questions to Richard, or questions. And Richard will address any logistical issues that you might be having, or any questions about CLE credit or anything like that. But he will forward to me any of your substantive questions, and I'll post them as we go along. I'll do my best. Those of you who are watching us on YouTube through the streaming, you're not going to be able to submit questions there, but certainly we'll welcome our audience on Zoom to do so. And one question already that's come in, and I guess, Peter, you could answer this as well as anybody. Hasn't Justice Breyer been wanting to write this very opinion since he first heard Lotus v. Borland when he sat on the First Circuit?
Well, that's an interesting part of the history, that he was initially on the panel in the First Circuit and then was nominated to the Supreme Court. And for reasons that I don't know are widely available, he recused himself. And the case was handled by his colleagues.
Before the First Circuit.
Right. Judge Stahl wrote an opinion that, sounded a lot like what I would think Justice Breyer or Judge Breyer would have supported as well. And even in this opinion, he references several times Judge Boudin's concurrence. So I think this is, very much on his mind. When he gets to the Supreme Court, he ends up sitting among the 8, but there's no decision out of that panel.
Do you have one last question, Peter, and then I want to get to Pam and Sean. Are you aware of any other cases pending in the district or appellate courts now that might decide the copyrightability issue?
I don't think so. None come to mind. I mean, there was a Cisco case that was sort of parallel to Oracle Google, but that's no longer active.
Pam, obviously you've been following this issue for a very long time, have had strong opinions on both the copyrightability issue as well as fair use. My initial question for you is, first of all, what does this mean within the context of the software industry? And then secondly, what does it mean for other copyrighted works, but just within the software sector, the computer sector, what is this? What do you see the implications here?
I think they're very broad. So part of the reason is that the Breyer opinion talks about the functionality of software, talks about the tasks that software can do as not protectable by copyright law, says that method calls are not even being claimed as protectable, says that that Cantu intended for copyright protection for computer programs to extend no farther than was necessary for incentives to create, talks about the difficulty of applying traditional copyright doctrines to computer programs. So a lot of the points that have been made in cases like Lotus v. Borland and Sega versus Appellate and the like, and those cases actually, I think, are elevated in their significance because by citing Lotus v. Borland a few times, by citing to the Sega versus Appellate and the Connectix case and Lexmark, those are all basically saying these the kinds of things that courts were grappling with in those cases are things that are relevant to this interface issue. But to me, they also have some bearing on merger defenses in some cases, on copyrightability challenges on certain other aspects of works. And the court's fair use analysis has a kind of a breadth as to each of the factors. So the court's not trying to make just a decision about just this case. I think it's trying actually quite clearly to speak to software protection as having a thin scope of protection, and some parts of software get even thinner protection than others, and focuses on the capabilities of the software, on the different kinds of creativity that might be required. And to me, this kind of brings back thoughts about the Computer Associates versus Altai case and ways in which the court there was concerned about the need for programmers to be able to do efficient things, right? So efficient elements of computer programs were not protectable by copyright law under the merger doctrines, the Second Circuit said. That means that that's another way in which the courts had taken into account what programmers need to be able to do. So to me, it sets a stage for a broad understanding about software. And software is not like other literary works. That's one of the sentences that I was very heartened to see in the opinion.
So just to jump to that second question, do you see in the court's interpretation of the fair use factors, do you see implications for other kinds of works or not?
Yes, I do. And for several reasons. One is because of the breadth of the way that the court talks about it, the reinforcement of transformativeness as something that really should be given a great deal of weight. And to be able to sort of say that using the same commands for the same purpose is transformative in this context because of all the creativity that it enables, that rejects directly the arguments that not only Oracle was making, but one of the reasons that there were, I think, 6 copyright industry briefs submitted was because they were afraid that if the court did reinforce transformativeness, that would have spillover effects. So they wanted to confine what transformative means, or to say that, you have to be one of the 6 favored purposes. And I think the court in this opinion even gives the example of something as transformative was a painting of a copyrighted logo that precisely replicates it, but is doing so in order to convey a message about consumer kind of, I don't know, kind of criticizing consumer activities. So it seems to me that the court actually, as to each of the factors, and especially as to the harm factors and the spillover of transformativeness as to the other factors. So if it's transformative, commerciality is weighed less heavily, and so forth. The court also makes clear that it was intending to, in this case, kind of reinforce its other fair use decisions.
Well, let's bring Professor Sean O'Connor into this. Sean, you also signed on to an amicus brief in the case. Let's go back to the question I first asked Peter, really what we started with. In your view, is the majority decision really about fair use, or do they sort of show their colors with respect to copyrightability?
No, thanks for having me in. I really appreciate the opportunity to be here. I have to go a lot with what Peter said. I do think it really was a way to get a copyrightability. And I think that when you look at it because of this effect to say, to distinguish categorically the declaring code from implementing code and this kind of terminology, Peter mentioned the creativity, but there's also the magic, is lacking in this stuff, that this really is an attempt to get at the copyrightability through fair use. So I think that does some potential damage to fair use because you're using it for the wrong purpose. And at the same time, we have fights for the level of copyrightability. So, my view is that once Congress made it copyrightable and did not distinguish between any different kinds of code, even though at the time of the 76 Act, it should have been apparent to Congress, what kinds of, that there would be different ways that you have different components of code. And they chose not to do that. So choosing not to do that and using in the statute terms like direct and indirect connection to processing, then really there should be no distinction here. And so the court is trying to make one where it may or may not be justified. So essentially, my take on this is really that in some ways this case is going to be the US v. Perry for software copyright. And what I mean by that, just like Goldstein then later comes in and looks back at the Perry case and says, judges should not be trying to figure out what's good art, bad art, what counts as art, what's not art. I think that in this case, you have a court trying to get involved in policy making about what constitutes worthy code, whereas code that is not worthy. I think they should have just gone straight at it with merger doctrine, even a sense-faire approach, almost like this is just stock stuff that could have been used. So there are other ways to do it. I think by using fair use, it's going to really confuse things.
And am I right that Pam was referring to the notion that, okay, software is copyrightable, but then there's thin protection and there's thinner protection. Am I right that you're rejecting that notion that there should be gradations within copyrightability of software?
Well, I'd say a few things. This may be
or within the copyright protection.
Yeah, I think one thing I should have said as a preliminary matter, I think I'm potentially on board with perhaps Peter and Pam that I don't really think we should have done copyright for software in the first place. That may be like heretical, but I think, going back to the days of my youth when I watched all the stuff being done through punch cards, this is really functional stuff. And so it should have been done patent, trade secret, some sort of sui generis approach. But it wasn't. And so the problem is, what we all might have wished to have happened didn't happen. It was made copyrightable. I think you can get to some of this by, I think, in Thomas's dissent, he does a pretty good job of saying, look, while functionality is a problem for copyright, but at the same time, we can't use functionality against software because we know it's functional, but let's distinguish the function, the abstract function of that piece of code from its actual written expression. So that gets to your thinness thing. I think what we probably all agree is that there's a certain thinness to the copyright on software because it can only be getting the exact written expression. It cannot be reaching the functionality of what's actually happening. My problem, though, is because of the way Congress does the statute and direct and indirect effects, then it's not clear how you determine what is more thin and how you actually measure that and quantify that. So that's what, again, makes me nervous, why I referenced the Perry case and then Goldstein as a corrective to that. I know that in other cases, we do decide something, a court says one thing is thinner copyright than another. But I don't know. Again, the better approach here is to go merger doctrine or sense-faire, not thinness of copyright.
Tom, listening to the three professors and knowing that this was such a long-running issue, such a contentious issue in sort of approaching the Supreme Court. You clearly have Justice Breyer very steeped in these issues. You would have had Justice Ginsburg perhaps as well, but other justices not so steeped, and certainly I would probably say other than Justice Breyer, none of them quite as deep on the history and the sort of back and forth. As an oral arguist, how did you approach this case, and how did you try to simplify it without talking down to the judges, which is never something you want to do? I mean, how did you conceptualize the case, and what did you feel was the best way to present it?
Well, of course, you have to distinguish between the briefing and the oral argument. The great bulk of the thinking at the Supreme Court happens in response to the briefing and before the oral argument ever happens. So there were lots of incredibly valuable briefs, including the ones authored and signed on to by the other folks on the panel. And so the court had infinite materials, 100 briefs. So there was no shortage of educative effort on behalf of the parties and the amici. So when you talk about coming to the oral argument, one of the puzzles about the oral argument in a case like this one is, particularly when you had the COVID-based telephonic oral argument, the prospect of it being utterly scattershot is huge, because the justices are going to go seriatim. One is not going to follow up on questions of the other. And we had both the copyrightability and fair use questions. And then there were two subparts to each of those questions. So essentially 4 different issues. So you could be bouncing all over the place, and the oral argument could be essentially incoherent. So there had to be, a real effort to be very responsive to the particular question that's put to me. But my bigger project overall was trying to count out in my head, among justices who I felt we needed, whether we had a chance at copyrightability or not. And by the time we got to Justice Breyer, I had decided that we didn't, and that that the court was not really amenable to our copyrightability arguments, whether with respect to 102B or merger. And so for the rest of the oral argument, I pivot to fair use, which is how this thing ultimately plays out. Our meta strategy in the case was to, through the copyrightability arguments and the merger arguments, to diminish the significance and the value of the work down to the point that the court would either just agree with us on copyrightability or, and this was more likely, decide that it was fair use because there was a lot of upside and we weren't losing very much because this work wasn't very valuable. This part of this work was not very valuable. So the case is a particular challenge because you have 8 justices with varying levels of sophistication, varying levels of hostility, operating from varying premises. The Justice Breyer and Justice Thomas, for example, take quite different views of the record. And the history of the negotiations and how it is between Oracle and Google, how it is that Android came to be and the like. But what I decided about 10 minutes in is that we were just going to consistently swim in the direction of fair use and just go for that.
Fascinating, just amazing. Let me go back to Peter. We've got a ton of questions coming in. I apologize to the audience. I'm not going to be able to ask but a small percentage of them, but do keep them coming because they're great questions. In a way, this will be for all 3, Peter and Pam and Sean, which is this a tenable distinction? That is, okay, these 37 declarations were taking them and copying them was fair use. Okay. And of course, the court did make it clear that this was pretty fact-based, but is this a line that can be maintained? This line between declaring code and implementing code, or is it just applicable to this one case? Or what are the implications more broadly? And if you look to sort of the evolution of software, is this even a line that still exists? Will it continue to exist? Peter first.
So I'm going to say that this is largely a line that has existed since the early 90s, if not before. And it goes to the one thing that has driven every major software copyright case, and that's people want to join a network of machines or software or users. And in the early era, we had cases like Sega, where Sega was trying to regulate access to its video game controlling system. And it did so by keeping the code for interoperability secret. And Accolade figured it out by making hundreds of copies to then, through a process of elimination, identify the precise hooks that you needed to be able to plug in a cartridge to their system and have it work. And I'll quote from that case, and I think this is the clearest statement, and this is what I wanted Tom to push. He kind of backed away a little, and I know why, because it didn't win the Lotus case. But the Ninth Circuit said, the functional requirements, is a quote, functional requirements for compatibility with the Genesis video control console are aspects of Sega's programs that are not protected by copyright, period. 17 USC section 102B. I think that's the principle we've been operating from all along, that it's easier to write code where you don't have to worry about interoperability. If you're writing from scratch, that's a constraint. It adds to cost. Google was hoping to license the implementing code, so it didn't have to do that. And so what has driven the industry and what we know about these markets is that they are heavily dependent on widespread adoption, what economists call network effects. And that's what people debate about. They're willing to write and implement code, but they want to be able to tap into these network effects. And that's what's going on.
But I guess my question,
partial
Peter,
partial response to Sean, let me just say, declaring code is not code. They're talking about declarations. A declaration is a function, a variable, a constant, or a class. And so I don't feel this was a case about code at all. I think it was a case about these structural elements, just like the QWERTY. I mean, that is not code. It's a way of allowing a user to create letters on a screen or on a paper. And that's why Justice Breyer, I think, was focused on that example.
But whether
I agree with Peter on this point. The 83 computer scientist brief, I think, did an excellent job really explaining what an interface is, what the function of the declarations, and Joshua Block and the other amici computer scientists basically do not consider what Oracle calls declaring code to be code. The declaration is an interface, and the cases have been really quite clear that interfaces are not protectable by copyright law. Implementations are. This also goes back as a norm in the computing field. And there was testimony, as I believe Tom can tell us, testimony by computer scientists that basically the distinction between interfaces and implementations is a long-standing one. I remember inviting a computer scientist to the Last Frontier conference that Peter Menell and I tried with Dennis Karjala organized, and our computer science expert, who is a professor at Carnegie Mellon University and a very well-respected computer scientist, basically says, well known in the field, implementations are different from interfaces, and everybody should be free to do this. This was also Sun Microsystems' position from the get-go. It formed the American Committee for Interoperable Systems, and it filed briefs in many of the cases, the Altai case, the Lotus v. Borland case, and the position of Sun Microsystems at the time was interfaces of computer programs should never be protected by copyright law. They are unprotectable procedures and methods within the meaning of Section 102B of the copyright statute. Sean, I think a point that I wanted to respond to you is that Congress might have used the wrong words, okay, in 102B because they drew method of operation, system, process, and procedure from the Baker v. Selden case law. So they didn't really know enough about computer programs to kind of distinguish between interfaces and data structures and this element and that element. So there's kind of a mismatch. I think that's one of the things that Tom had to grapple with, is that the words of exclusion in Section 102B that are meaningful, I think, in computer programs cases, it's because Congress added those words in order so that computer program copyrights wouldn't be construed too broadly. So those are just another few things to throw in the hopper.
Sean, just let me interject here. We did have one contribution in the chat, not a question, but sort of answering my question and reinforcing Peter's point. The participant writes, from a computer scientist's perspective, the line between declaring, in quotes, and implementing code is crystal clear. In fact, declarations are not even seen as code. We computer scientists don't use the words declaring code. We see them as specifications. But Sean, respond to any and all of the above from Peter or Pam. Is this a clear line? Is it the right line? What are the implications here?
Yeah, well, a lot of stuff to work with. First, I mean, like both of them too, I do have some computer background. That's why I started out in college. I was doing computer science programming back on mainframes. So I do get a lot of this, and I wouldn't mind getting into the technical details of it, although I'm not the master of it, so I'm not the best person to do that part of it. However, here are the issues. So first off, we're kind of stuck with statutory language as it is. Isn't this, and that's my concern with the case, is taking it through fair use. This really is something where if the statute's wrong, if the statutory language is wrong, Congress should have to fix it. And otherwise, we're kind of stuck with the statute as it is. And I think second, if we want to fix the statute through the courts, which I guess can be okay too, and I understand why Tom is saying, I think pragmatically, look, he won the case, so that was great. He went for the fair use angle. But what both Peter and Pam are arguing is this is a copyrightability issue. And yet the court didn't do that. So that's why I'm saying that they muddled it by going through fair use. And I know that they only say we're assuming arguendo that it's copyrightable, but that's really a problem. They should have just taken it on head on. And I think that would help. I think that would actually help Peter and Pam's point if we just had a clear ruling that this stuff is not copyrightable. Let the computer scientists come in and argue all this and say that it's crystal clear, that even though it's language, it gets processed. I mean, to some degree, I look at, and I think this is the problem for Congress defining it. They're just looking at, I don't know, there's text strings that end up being converted into, object code, ones and zeros, they get processed by the CPU, and then stuff happens, right? And that's kind of probably the extent of their level of understanding it. So then we can distinguish it, but geez, Congress needs to fix the statute then, or the courts just need to take it on square on the chin and say the stuff is not copyrightable because it's not code at all.
I mentioned one thing that is an interesting, sheds a side light on the question of whether the instructions, the specifications, the declarations are copyrightable. One thing that's really noteworthy is to go back to Oracle's original argument in the case. Oracle's argument was, to the extent it wasn't patent-based and they moved on to copyright, was fundamentally in the district court about the structure of Java SE, the organizational arrangement of all of the methods. And it was only indirectly that the declarations even came into the case. The district judge confronting the question of whether the structure was copyrightable attacked it, who the judge spent an enormous amount of time, learned how to program Java. It was incredibly impressive. The district judge came at that question by saying, well, look, I can't tell you whether the structure is copyrightable without figuring out whether the declarations that create the structure are copyrightable. And he said, well, I don't think those are copyrightable. And in turn, I therefore don't think the structure is copyrightable. Oracle, and this is in the first appeal in the case, took up the question, not only whether there was copyright protection for the structure, but also for the declarations, and got the Federal Circuit to rule that that was now in the case. And after that point, the case became very, very, very much focused on the question of whether you could copyright the declarations, which I always thought was pretty dubious. But that kind of turn by the district judge and then Oracle's decision to embrace it kind of hijacked the entire case. And so there's very little discussion actually in the Supreme Court's opinion about Oracle's original theory of the case, which was that this was about Google stealing the structure of Java SE's arrangement of all the methods. There's a like passing mention of it. But the case in the end looks nothing like the case that Oracle brought. And it's just an interesting illustration of how early decisions can take you down some paths. And, I'm not sure that Oracle in the end would make all the same choices. I mean, you have to give them enormous credit for having, won handily twice in the Federal Circuit. So it's very hard to argue with. But in the end, they were left with a case that they did not bring.
Yeah. We had a couple questions posing more or less the same question as follows, directed to Peter and to Pam. Does this decision have any implication for patent law in terms of what is patentable?
Well, I'll start. I don't think so. I don't think that the Supreme Court really added anything to that, I'll say, morass. And software and patents don't mix well either. But I do think the Patent Act clearly embraces processes which are machine instructions. And, I would like Congress to solve that problem because the Supreme Court has kind of reached the end of its tolerance of that issue. But I do think that there's an interesting history here. If you go back to the O'Reilly versus Morse case, among the claims that Morse protected, and the Supreme Court did not dislodge in the famous case about the telegraph, was a claim to Morse code, to the particular code. Now, that was not, I think, directly challenged in the case, but it was protected. And then you have Baker versus Selden coming, a couple decades later. And in that case, I think the Supreme Court is very, very clear. And this is why I wish it was addressed in this opinion, because the Supreme Court was saying there are lots of ways, implicitly they were saying there are lots of ways in which you can organize forms for double entry bookkeeping. And we're saying that this is a method of operation. That's why I'm not that upset by the statute. I think it's a very broad way of saying that a method of operation is ineligible. And we're going to deny you protection under copyright because you would have to go through the utility patent system, which they didn't. They had tried and failed in Baker versus Selden. So I think that we do have some really interesting old case law that addresses these questions. Now, over time, courts realized that patent law wouldn't be a good place for dealing with business methods or printed matter and other things. So I don't think we're going to see a change in patentability, but that is perhaps an equally important question for the Supreme Court or Congress to address.
So I think that the issue had been posed at the trial court level. One of the reasons that Judge Alsup decided that these declarations were not protectable by copyright law was because he saw that both Sun and Oracle had sought patents and obtained patents on some interfaces, and so it seemed to him that reinforced the notion that they were not patentable. Now, when the case gets up to the Federal Circuit basically says, well, just because these interfaces are potentially patentable doesn't mean that you can't also get copyright protection for them. And that, of course, blew my mind. So the issue was kind of presented in the case. One of the things that Google pushed more on its first petition was this kind of, this is really patent subject matter, not copyright subject matter. That issue was also what split the Supreme Court in the Lotus v. Borland case. And I think here's the hard thing. It's very difficult for the Supreme Court justices to think that a selection and arrangement of words is patent subject matter. It just doesn't feel right. I think that was part of the problem with the command hierarchy. And instead of going with the kind of compatibility argument that ACES made to the First Circuit, and to the Supreme Court, there was this kind of desire to say it's patent subject matter, not copyright subject matter. I think this is a place where things are ambiguous, but I think it also feeds into this notion that the scope of copyright protection for computer programs should be thin, because there are patents out there too.
Yeah, I'll say that I think that the two things about this. The first is, I do think the Federal Circuit, which has so much patent experience and so little copyright experience, treated all intellectual properties pretty similar and effectively treated copyrights as patents. And what the Supreme Court has done here by overturning that decision is probably returned them to their separate boxes. And therefore, I don't think you'll see a kind of an IP limiting spillover from a fair use holding on copyrightability here, but rather you'll get this, courts will tackle this as a patent question, and whether it's, it is copyrightable subject matter. The second is that we tried to pitch the case as an end run around the Supreme Court's software patenting cases, as if the Federal Circuit, confronting the strict limitations on software patentability that the Supreme Court had adopted in overturning Federal Circuit precedent, had trying to find another way. I have no idea whether it made some difference behind the scenes, but certainly there was no external appetite for that argument whatsoever. None of the justices signaled that they agreed with us in any way. So I think that this probably almost certainly is not patentable subject matter, but that will be the framework for analyzing this sort of thing. And that may well be where it returns, because while it's true that the Supreme Court has left copyrightability unresolved, in so many contexts, the fair use holding is going to be controlling, making moot there the copyrightability question, just as it is here.
One quick follow-up.
And Jim, a little bit to this.
Yeah, Sean, let me just ask Tom one question,
sure.
Sean, which is, did you sense any techlash, that is any sort of overall perception of the good or the bad of the tech industry, and whether Google was the white hat or the black hat? Or I didn't sense that in the opinion, certainly, and I didn't necessarily sense it in the oral argument that I heard. But was that floating around?
Well, I think that our pitch to the Supreme Court was that the developers, the little guys, were our heroes, and we were standing in for them. That this was very much, Google was going to be okay. We were going to make it. But what the rule of the Federal Circuit was going to do was to make it much harder for independent developers to have the ability to use the skills that they had learned on various platforms and apply them on other platforms, that they were going to get locked in by large software companies, whether Oracle or somebody else like Google. And I do think in Justice Breyer's opinion, you do see that, the idea that this is, it is fair use when you are trying to unleash the knowledge of the developer community. And I don't know that that's techlash or just the notion that those are creators that we want to empower.
I think it's brilliant lawyering that you took a case involving two tech giants and made it about the little guy.
We're the little guy. We're obviously the little guy.
Sean, you were about to jump in, and I also have a couple follow-up questions for you, but what did you want to get in on?
Sure. I want to just jump back for a second. I'm not as sanguine about Tom as it being kind of cabining. I think if anything, when you ask the question about does it have implications for patent law, I think it's almost the reverse. What troubles me a little bit about the decision is I feel like it is importing, almost like some flavors of genericide from trademark. The more successful your open interface is, then the more, well, everyone's got to use it. And that's Tom's argument. And look, as a guy who often represents startups, I'm very sympathetic to the small guy and their ability to access the system. But this is a little bit of the problem for, let's say, a mid-size or than a large company that's creating a platform. The more successful they are, the more I guess it's going to be fair use to let everyone access it. I also think it imports some of the kind of standard essential patent logic from patents, as well as the kind of what's more important and what's not. So I think the decision is really just going to muddle those lines a little more. I think, and this is a temptation often for not necessarily the federal circuit because they're so patent focused, but other courts, it's just kind of blurring that line between different IP areas and kind of importing doctrines from one to the other that maybe shouldn't be imported.
Mm-hmm. Can I just mention one thing about that?
Yeah,
because I do think it's a very real concern. I think that the biggest debate in the future about this opinion is going to be how much weight you put on Justice Breyer's description of Android being not a competing platform, but rather something quite new and transformative. Because there are going to be parties that attempt to reuse interfaces to make just a straight up competitor to something else. And then there's going to be a much more significant debate, I think, on whether Google versus Oracle controls there. Whereas if this had been decided on copyrightability grounds, you would know, no, you can reuse the interface even to make just a one-to-one straight competing platform.
Straight compete, yeah.
And so to Sean's point, it was at least significant to the court that they agreed with us that Android was just a very, and well, with Judge Alsop, that Android was a very different kettle of fish from Java SE. And I wouldn't deign to predict the outcome of what the Supreme Court would say if you were to make, just another version.
A laptop or desktop.
So I'd like to weigh in on this because I'm going to disagree with you, Tom. I think by virtue of having cited approvingly to Sega v. Appellate and to Sony versus Connectics, you have two cases that involved. I want to control the proprietary interface, and I want to interoperate with it. That was enabled through Sega v. Accolade, and then Connectics actually is a competing platform, right, for applications that had been written for the PlayStation. Connectics wanted to be able to do it. So to me, the Supreme Court, having cited positively to those opinions, I think leaves open the possibility that in fact it's going to be possible to win on fair use grounds, even when there's a competing platform.
Oh, I'll give you the possibility is open. There's no question about it. I just, I would hesitate to overread the Supreme Court's citation to what you and I and the other people on this webinar and the audience know are very significant Court of Appeals decisions, but it's not front of mind exactly what's going on. And so I agree, it's an open question, but I think it's in fact the most significant open question. It could end up either way. Those are very good examples where the courts quite plainly do see the value in the creation of the competitor. It's a little bit different, because if you have reverse engineering, you may have a different form of copying and reuse. But I think it's a fascinating question.
Pam or Peter, any impact on, for example, music cases? Pam, I mean, among the four factors, does what the court said about any of them implicate music, photography?
Oh, I think photography is a closer analog because a lot of times photographs have a kind of factual character to them. And so the scope of protection for photographs actually varies along the kind of how expressive is it versus how factual is it. And the courts have actually, different courts have gone different ways about this. But in the Rentmeister case, for example, you had something that was a very creative image of Michael Jordan doing a basketball thing, and the court is very, very, very creative. But actually, there's no infringement because of this difference and that difference. So it seems to me that the photographs are more likely to be implicated. I think music is just farther away from that. But even in some of the recent music cases, courts have actually been kind of doing more dissection and filtration of things that are kind of common in works of those kinds. So it does seem to me, but fair use rarely is raised in music cases. Ed Lee has written an article basically saying maybe it should do more, but fair use has been important in a lot of the photography cases.
How about the Warhol case in the Second Circuit?
Well, it won't surprise me at all if there's a motion or a petition for en banc review of that decision in light of the Google decision, because the sort of lower court's analysis, the Second Circuit's analysis of transformative is, I think, completely at odds with what the Supreme Court's new articulation of transformativeness is about, and also the spillover of transformativeness for other factors. So I'm not going to be surprised if that happens sometime soon.
Mm-hmm. Peter, thoughts on music or photography or other works?
Yeah, well, I think the contemporary music cases have not raised fair use, but the Campbell case was a music case, and I think in the hip hop, in those kinds of cases, fair use probably becomes a bit more usable. The Supreme Court, just as it says, is not dealing with copyrightability, and then it does. It says at the end, this is limited to software, which of course it isn't. And their language about how to think about market effects, I think, is going to find its way across the fair use case law. I think this opens up ways for lawyers to characterize public benefits. The Supreme Court says that this case, though, was a very specific type of benefit to the millions of programmers who had mastered the Java language. So a case for me where this might be more in play was a case that I was involved with, Pam, as well, although we were on different sides. This was the Dr. Seuss Enterprises case. I still think that case would come out the same, but I would say it would be easier for Comic Mix to make its argument after this case than it was before.
Based on transformativeness?
I think that they could say, this is such a widely used Dr. Seuss, meme, that they could try to kind of use the public's familiarity with the characters. But frankly, the record in that case was so strongly contrary to it being transformative, and that they were talking about, we want to sell mugs and T-shirts, and they were not trying to be critical. So, it could come out a little differently. Now, I'll say, partly because this was the paper that you referred to from 1986, I proposed, not as a reconceptualization of all fair use law, I proposed in the paper for Judge Breyer's seminar the use of essential facility and genericide logic in thinking about interoperability. And I think it's a good match there. I wouldn't want to see it metastasize throughout copyright, because I do think that that's a bigger issue. But when we have some literature about copyright in time, Justin Hughes and Joseph Liu have written about this, and they make an argument that as works become so widely known, Star Wars, and so deeply ingrained in the culture, that potentially could affect the balance. It didn't in some of the more famous cases, but I think it's just a matter of economic logic and social welfare and promoting progress, that there is a sound basis for bringing that in. And this case opens that door a little.
Let me go to Sean for 1 minute, and then I want to conclude with Tom and his sort of closing 1 minute. Sean, you're editing a handbook on music law. Do you think this decision, are there sentences that parties in a music case will pull out and use, or not?
No, yeah, thanks for teeing that up. I'm going to go with the most valuable thing, depending on what you decide on music cases, is Tom's approach. In that essentially I want to also call out Ed Lee's article on this, but I think Ed's looking more at traditional uses of fair use and the way we often look at it effect on the marketplace. But this gambit of saying, look, if I don't think I can get there straight ahead by merger or sense affair, in music, that was what Blurred Lines was looking at. Or the thing is this really just the beat, the groove? Is there stuff that's really not music? It's kind of in there, but it really shouldn't be seen as part of the music. And I say that sort of reluctantly because I think that stuff should be protectable. But I think this is a great roadmap. Tom's thing is unfortunately a great roadmap for how to go about using fair use when you don't think you can win on merger and sense affair directly in music cases.
Fascinating. Tom Goldstein, 30 seconds, closing thoughts.
Well, I think that one of the lessons, just given the nature of the panel and Berkeley's involvement here, one of the lessons that I think is probably missed is that the court really was, I think, looking to the communities much more than it was to lawyers like me. I do think that, Pam has rightly pointed to the computer scientist brief, but there were several academic briefs and the like. And our broader strategy was just to say, this can't be right. Look, the entire world is on our side, at least the world of smart people. And this is going to upend something that people have understood for a long time. And so figure it out. And I do think while, they're in Supreme Court litigation, we think about reasons and excuses, the opinion that the court writes. But I think that in general, the court was just recognizing that this is re-implementing interfaces with widespread practice for many decades. It had to be okay. It was really important to developing new software. And that's kind of the bottom line of what they're trying to do, rather than a lot of nuance on, for example, fair use.
Yep. Very, very, very good closing comments. Thank you all. Sean O'Connor, Antonin Scalia School of Law, Pam Samuelson and Peter Menell, Berkeley, and Tom Goldstein.